Okay, we are back in Senate Judiciary, April 2nd. We're shifting gears to H98. We have Judge Zone.
So good morning. Again, Tom Zone, Chief Superior Judge. H98, the bill on confirmatory adoption for children born through assisted reproduction. This is a policy decision for how to address these circumstances. Currently, there is an ability for individuals to seek adoption through the existing process. The policy, I understand, that was sought to be advanced by this is to have a recognition that these types of circumstances are different and don't fit as well into the existing structure. So this process was developed in order to have a more streamlined and direct approach to address the circumstances that arise in these situations. We did testify in the House and provide some suggestions on the language that was adopted by the House and approved. And as far as the impact on the courts, where the parties do have the opportunity to come to courts now, this would actually, I think, lessen the impact on the courts in some ways because it has a more streamlined process and it provides a procedure that is one that does not take up, if you will, as much time as the other procedure would take. And again, the procedure that is developed here under H98 is one that fits better for these circumstances. And so we have no objections to this bill as far as impacts on the court, and we can make it work.
Thank you. And since we are intending to attach F95 to H98, are you able to speak at all to S95?
I can. So again, it's a policy decision for how to address it. My understanding is one of the reasons that this bill is was advanced is because there is a concern that the existing law may or may not provide a basis for that. And I think that there could be different judicial views on that. And so this makes it clear what the process is and how to make sure that there is availability for this type of guardianship. The bill does provide there's a few sections of it that I want to touch on page 11 and I'm looking at the introduced version. Is that the current version?
Yes.
Okay. On page 11, it indicates that on lines 9 through 14, it includes a 45-day provision there. And we don't know the impact here. And this really ties into one of the areas that we need to recognize in the court, and that is we don't know what impact this bill will have on the courts. We don't know if we will have 20 applications, 20 petitions, or 200. So I would suggest that Legal Aid and others who are working on this bill, they may have better ideas on numbers. And I have heard some numbers, but I don't know what the final numbers would be. There is the potential for this bill to have a significant impact on the courts for resources and judge time and staff time. So that could occur. If it does occur, we would certainly let the legislature know what our needs would be. But as of now, we don't know what the specific impact will be. But we're busy in the probate courts now. The judges have a lot of guardianships. They have a lot of other matters to deal with. And having a 45-day timeline with no ability to extend that or come outside of that, I would suggest adding some language that would allow the court for good cause shown to issue an order after 45 days, or just change it to say it shall establish the guardianship promptly after the petition is filed. That gets you to the same end result, but doesn't put an artificial timeline in. The goal of the court is to have any guardianship, and would be with these also, to be issued as soon as possible. So if you had promptly there, that would work, and it doesn't put a timeline in. The bill also talks about on page 14, line 10, it requires the court to email something to the custodial parents at their last address. They would be represented by counsel, and under our rules, documents and materials go out to counsel, who then has the responsibility for making sure they go to their clients. So having email, I understand that, but it does put a burden on the court to email to someone who's represented already, when it should just come from their attorney to have that contact. And on page 15, lines 1 through 4, this is the section on termination of the guardianship. And it allows the guardianship to be terminated if you, basically it says you don't have to meet format and signing requirements for the motion. And I know that there is some concern that has been expressed over this, that it's an important component of the guardianship for the termination, and the court should have a level of information that it would have for other guardianships to make sure that if it is being terminated, it is being terminated with the consent and knowledge of the parties like that. So having it not have to conform, I'm not really sure of that is the best way to go. The idea is to make sure that we get accurate information. We're going to terminate it. We want to make sure that everyone knows about it and it's being terminated properly. And there's already a termination structure that we have for guardianships.
Do you happen to know the context or background as to why specifically they're saying here, or that it's suggested here that the filings don't need to meet the format and signing requirements?
I suspect that what it has to do with is if a parent is subject to an adverse immigration consequence, they may not be in a location or an area to be able to sign. And so I think that is possibly where it comes from. And so I think what we're really dealing with is a policy decision as to the ability of the court to act. You could change that to let the court have some flexibility. Instead of saying the court shall accept filings, you could say the court may accept, for good cause shown, the court may accept filings. That would provide the flexibility for the court to address those circumstances where the parent may not be able to sign, but it doesn't require the court to accept it if they can sign. And this current language would actually require it even if they were available.
Thank you. And
the only other thing I want to point out, it is my read of this that the consensual paperwork for the consensual guardianship, while that would possibly be filled out before an adverse immigration consequence was felt by the parent or guardian, the paperwork is not to be filed with the court until the adverse immigration consequence happens. In other words, the court is not going to be getting petitions and issuing guardianship orders unless the parents have had the custodial parents have already had the adverse immigration consequence. I think it should be clear. That's how it is viewed, because otherwise the court couldn't issue the order promptly upon the filing or within 45 days, because if the adverse immigration consequence hasn't yet happened, there would be no basis for that. So I just want to make it clear. It's my view that these don't get filed until the adverse immigration consequence occurs. And that also impacts the courts, because if you're having 100 of these petitions filed and they're never needed, well, the court has spent a lot of time and resources on something that didn't occur. So the idea is, yes, when it happens, it gets filed and it's held by the attorneys, as I understand it.
Thank you. Committee, any questions before we adjourn? Hey, Judge, thank you for your time.
Certainly, my pleasure. Have a good day, everyone. Take care.
Oh.